Good afternoon, and thank you for joining us for an MP webinar covering the 2023 HR Legislative Update, Regulatory Alerts, and Guidance. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and a deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenter for today's program, Paul Carelis. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM-certified HR professionals at MP. Together, they assist clients with compliance, training, and HR guidance and support for the full employee life cycle. Paul has spearheaded MP's Employee Retention Tax Credit Services. This initiative has helped thousands of clients claim over $100 million in refundable, advanceable tax credits. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen, and we will be sending out the recording of the webinar later today along with the slides. And with all of that, I'm going to hand the mic off to Paul.
Great. Thank you so much, Katie. Really looking to diving in. There have been a lot of changes at both the federal and state level, and also a lot of federal agencies keeping us on our toes, so looking forward to review it all. Just quickly, hope you get a lot out of today's seminar. It's coming from a HR best practices perspective. Please don't construe anything today as legal advice, and this information should all be current as of today, January 18th. So in terms of what we hope to cover, we'll do a legislative overview. We'll cover a couple of key bills that were passed in the last month. We'll also talk about some upcoming Supreme Court cases that could have a wide-ranging effect on businesses, in various industries. Again, we'll give an update on some of the federal agencies, the Department of Labor, the National Labor Relations Board, and some others. We'll go over some new state laws that were either recently signed or going into effect in the new year. We'll go over some of the 2023 trends and also kind of look into our crystal ball for an outlook for what to expect over the next 12 months. And as always, we'll do our best to answer any questions that you may have. As Katie said, feel free to throw those in the Q&A on the Zoom, and we'll do our best to get to those. So first, just a quick COVID update. In terms of CDC guidance, current CDC guidance, if someone is COVID positive, they should isolate for 5 days. One newer wrinkle is if symptoms were moderate or severe, usually that has to do with affecting lungs and breathing, those folks should isolate for 10 days. The latest CDC guidance also advises people to stay away from folks who may become very sick for 10 days as well. So people that are at higher risk of getting more severe COVID. For folks who are exposed, not necessarily testing positive, those people should mask for 10 days and take a COVID test after 5 days, or if they start to develop symptoms. Currently, CDC is not recommending any kind of random asymptomatic testing, so they're recommending against testing employees before they return to the office or anything like that if they're otherwise asymptomatic. And then in terms of employment law circles and things like that, there's a lot of talk in terms of OSHA, because generally OSHA relies upon CDC guidance to set their expectations and their expectations for businesses keeping their workplace safe. So for businesses who kind of do not follow CDC recommendations, have people coming in not following the isolation rules and the masking rules, there is the potential for those businesses to be subject to OSHA violations for not following the general duties clause, which requires a business to, again, keep their workplace free from unnecessary harm and safety risk. All right. So again, a couple of really big and important bills recently passed at the federal level. The first of which is called Secure 2.0. So this has to do with 401ks, 403bs, other defined contribution plans. And by no means am I an expert when it comes to retirement. I'm not a retirement advisor, but we'll go over kind of high level what was included in Secure 2.0. Some of these are mandatory changes. Some of these are kind of optional enhancements to 401k plans that employers can decide to include in their future plans. But again, if you want more details or to see how these affect your specific retirement plan, please do speak to your retirement advisor or broker. So for once this goes live, new 401k plans are going to have a new requirement for automatic enrollment. So that means unless the employee opts out, they will be automatically enrolled in the company's 401k plan upon hire. There's also a mandatory allowance for part-time workers. So there was also a couple of years ago, I think in 2019, Secure 1.0. So what the Secure 1.0 Act required was that if a part-time worker worked at least 500 hours in 3 consecutive 12-month periods, then they'd be eligible for the 401k. Secure 2.0 knocks a year off of that. So basically, if someone is part-time but working at least 500 hours in 2 consecutive 12-month periods, they will then be eligible for participating in the 401k plan. They're also doing a gradual increase to the minimum distribution age. That's eventually going to, excuse me, become 75. Another change will allow for employees to elect that employer matching funds go to Roth. They're also going to allow employees in their 60s to do additional catch-up contributions to their 401k in addition to what's allowed for workers who are 50 or older. There's also going to be the option to add an emergency savings account to a defined contribution plan. So there are monetary limits to that, but businesses will be allowed to have their plan design set up so that employees can allocate some money towards an emergency savings plan and then withdraw that money in case of emergency without penalty or taxation. And then another kind of cool thing that's part of Secure 2.0 is that they're going to allow employers to match an employee's student loan payments, but the employer match will not be going towards their student loan debt. It would be going into the retirement account. So basically, the purpose of that is so that employees, who may be struggling, really focused on paying off their student loan debt, will still be able to contribute to their retirement through the employer match while they're making those student loan payments. See a question here, do these apply to 403B and 457s? For many of these things, yes. A lot of these also apply to 403Bs and 457s. But again, you'll want to speak to your retirement advisors and professionals in terms of which aspects of it do and which don't. But for the most part, most of these provisions do apply to 403Bs. Another groundbreaking couple pieces of legislation that passed in the last month are the Pregnant Workers Fairness Act and the Pump for Nursing Mothers Act. So the Pump for Nursing Mothers Act provides reasonable additional break time for nursing mothers to pump or express milk. And the Pregnant Workers Fairness Act provides reasonable accommodations to pregnant workers. So the reason for this, and there are several states that have their own Pregnant Workers Fairness Act, but really the reason for this legislation is that technically under the Americans with Disabilities Act, pregnancy is not considered a covered disability. So there was kind of this loophole where unless they had some other underlying disability, pregnant workers were not afforded the protections under the ADA. So what this does is provides reasonable accommodations similar to ADA, not quite the same, but very similar. So some of the accommodations may include allowing the employee to use a stool, giving them some additional break time, allowing them for some light duty roles if they're still able to perform the primary functions of their job, or to have a water bottle with them if that's otherwise not allowed due to a clean desk policy or something like that. So similar to the ADA, these accommodations are allowed provided that they don't cause an undue hardship on the company. The Pregnant Workers Fairness Act officially goes into effect June 27th of this year. The EEOC is responsible for drafting the formal regulations and the official language of the PWFA, but they've been given up to 12 months to do so. So there might be some overlap where this goes into effect, but we don't have the actual formal regulations until a few months later. All right. There are also a few Supreme Court cases that we're keeping a close eye on because they could have, again, far-reaching effects on businesses in all industries. The first was actually just approved. So there have been a few cases like this that the Supreme Court had turned down from hearing, but just earlier this week they did agree to hear Groff versus DeJoy. So this case involves a evangelical Christian postal worker who worked for the USPS as a delivery person. But as time went on, at some point, the United States Postal Service started delivering packages for Amazon, including on Sundays when there historically hadn't been traditional mail service. Um, so they told this worker that they needed to be working on Sundays to deliver the Amazon packages. He requested an accommodation due to his religious beliefs to not work on Sundays. And for a while, they were able to accommodate that. They found other workers that could fill those shifts, but over time, they decided that they really needed him to work on Sundays, and did not allow that accommodation any longer. So he quit and sued the United States Postal Service. So, long story short, this could have really far-reaching effects. So, historically, in other court cases, at least in certain industries, kind of the requirement for Sunday work, and employees requesting an accommodation to not have to work on Sundays due to their religious beliefs had often been seen as an undue hardship on the business. That no, it's not reasonable to allow people to take that day off because of their religious beliefs. That it would cause an undue hardship on the company because of their operating schedule. So, depending on how the Supreme Court rules in this case, it could really throw things into a tailspin in terms of, other companies and what they do or do not have to accommodate in terms of religious accommodation. There's another interesting case, Glacier Northwest versus the National Teamsters Union. So this has to do with liability by a union or by workers, if they have protections under the National Labor Relations Act or not, if there can be a state tort claim. So this case involves a cement company. So the cement company had trucks on the road. They had a whole bunch of cement kind of mixed and ready to go. When the Teamster Union decided to go on a strike with less than 1 day's notice, and as a result, all of the cement that had been mixed was ruined. They were, fairly deep losses for the company because of those actions, because of the strike. So the Supreme Court is going to be hearing the case to determine whether there's liability by the union and whether they can be held liable for that expense. And then one that we talked about, I believe, on the last legislative update webinar that we did several months ago was Helix Energy Solutions versus Hewitt. So the arguments in that have been heard. We're just awaiting the ruling from the Supreme Court on this one. This has to do with overtime pay. So in this case, there was an oil rig worker who was paid a daily rate, and it was a fairly high one. I believe it was $963. So they were making over $200,000 a year. But they made a claim that because they weren't being paid a weekly salary, that they were instead being paid a daily rate, that they were non-exempt and eligible for overtime. So again, the Supreme Court has heard the arguments. It's currently under review, and we're expecting a decision on that case really soon. All right, so over at the National Labor Relations Board, still a ton of unionization efforts and attempts. A lot of businesses pushing back on those. National Labor Relations Board is being very mindful and really closely inspecting all of those cases to see, are the companies following the National Labor Relations Act? Are they violating it by, overly chilling unionization efforts? Are they following the law? They're keeping really busy making sure that individuals and unions are given a fair chance at an election. One really interesting new wrinkle that just came up a couple weeks ago, excuse me, is that the NLRB has instituted new fines for businesses who illegally fire individuals for unionization efforts. So these new fines, there typically hadn't been a ton of really hefty fines from the National Labor Relations Board, but these could be significant. And obviously this is brand new, so we'll see how it plays out and what, if any, monetary damages there are. But basically these fines would allow, for any financial harm that a business has caused an employee who was illegally terminated because of unionization efforts, they can find the business responsible for those financial harms. So that could be everything from credit card late fees, house or automobile repossession costs, health insurance or healthcare costs, lost income, child care. The list goes on and on. And again, this is brand new, so we don't quite know yet how far reaching it's going to be, but definitely something to keep an eye on, and it'll be interesting to see how this plays out with the initial cases to see how financially hefty they may be. Union activity and union elections are still very strong. In fourth quarter of 2022, there were 373 union elections with about a 65% union approval rate on those elections. A record-breaking number of unfair labor practice charges heard by the National Labor Relations Board. There were 18,000 of them in 2022. There were only, by comparison, only 15,000 in 2021. Over at the Department of Labor, still a big push as they announced that they were going to do. They definitely lived up to that promise. They are inspecting and auditing restaurants pretty much nonstop. We've seen several fines issued, several press releases from the Department of Labor about their findings. So we really only know about the ones where violations are found and that there's a news or press release about it. I imagine there's countless others that they're also doing that are able to pass. Big focus is on child labor, making sure that workers under the age of 18 are not working more hours or later shifts than they're supposed to be under the child labor laws. Also a big focus on overtime, making sure that employees are being paid overtime at the correct rate, taking into account the regular rate for that calculation. Seeing a lot of focus on fast casual restaurants and fast food when it comes to the fines and the inspections. Department of Labor through OSHA also just indexed and increased the maximum penalty for willful OSHA violations. And so this is the maximum. Oftentimes they're far, far lower than this, but the maximum OSHA penalty for multiple willful safety violations has now increased to $156,259. So nothing to sneeze at there for sure. That's up from, I believe, $142,000 and change last year. So something that we've been waiting on for a long time, and we're kind of relying on rumors and kind of insider info. The Department of Labor has announced that they will be releasing their proposed rule for Fair Labor Standards Act overtime changes in May. So a few months out, but They'll most likely be increasing the minimum salary threshold for employees to be considered exempt from overtime and other aspects of the FLSA. Not sure yet if there'll be any other changes to the duties test or anything like that, but we will expect to see that in May, and we'll certainly have some content on that once that is released. Also, a big Department of Labor focus on exploitation of foreign visa workers. There's a company in the Midwest that was just fined over $1 million for that exploitation. We've seen several other companies as well end up in the crosshairs of the Department of Labor and in their press releases. And then also a lot of action by the Department of Labor when they find that companies are retaliating against employees for participating in Department of Labor audits and investigations and things like that. So an agency that we don't talk about too often in these webinars is the FTC, or the Federal Trade Commission. But they kind of rocked the employment law landscape a little bit last month when they proposed a ban on non-compete agreements. This ban is really far-reaching and very comprehensive. It would essentially wipe out any non-compete agreements, with the only exception being when someone sells their business. In those cases, they'd be allowed from having a non-compete agreement from the person selling their business to not open up a similar business. Other than that, non-competes would essentially be a thing of the past. You know, there is the question, does the FTC have sufficient authority to do such a far-reaching ban? That remains to be seen. And at this stage, it's just a proposal. It hasn't become official just yet. But in their proposal, they did include some information from some surveys that they consulted, which said that about 18% of workers are currently working under non-compete agreements, and about 40% of workers have had them in the past. 30, it's a wide-ranging number here, so I don't know how good their data is, but they said 36 to 60 million employees would be affected by this ban. And looking further at states that enacted state-level bans or restrictions on non-compete agreements, they said that those have resulted in wage increases on average between 2 and 4%, chalking it up to that restriction on non-competes. All right, so states are busy as always. A ton of action on pay transparency. So over in California, many employers are now going to be required to include a pay scale on all job postings and also provide it to current employees upon request. California is also going to have an annual reporting requirement for employers with 100 or more employees, similar to EEO-1, but having some state level pay data and makeup of their workforce as well. That's going to have to be filed with the state on an annual basis. Rhode Island has banned asking or depending on salary history and employment decisions and in the interview process. And they're also going to be required to put wage ranges on job postings. Similar thing in Washington State with that requirement for pay ranges on job postings. In Illinois, employers with 100 or more employees are going to have to obtain equal pay certifications from the state and do, similar to California, an EEO-1 filing with the state. And for those of you who missed the last session, if you do have a presence in New York City, back in November of last year, New York City enacted a pay transparency law that requires pay ranges on job postings as well. Speaking of New York City, they've been tackling artificial intelligence. So they're restricting the use of artificial intelligence in employment screening and employment-based decisions unless that software has completed what's known as a bias audit. And even if it has, and they're going to be using it, they do have to notify employees or prospective employees that they're going to be using artificial intelligence as part of the process. Connecticut recently passed what's known as the Clean Slate Law. What that does is provide additional protections and additional erasures of criminal records. So it really restricts how criminal records can play a role in employment decisions. Washington, D.C. So with the FTC proposing a federal ban, in the meantime, Washington, D.C. has banned non-compete agreements for any employee considered not highly compensated. So you do see, and this was part of the FTC's report as well, several low-wage positions being subject to non-compete agreements, everything from, I think it was Burger King and Baskin Robbins and McDonald's were mentioned in the report. So the DC law would ban non-competes for people. Seeing a lot of data protection laws being passed at the state level. So California, Virginia, and Colorado are the newest that have provided or proposed and enacted additional data privacy and data protection laws for employees. And then also seeing more and more states enact Crown Act legislation, which adds hairstyles and hair textures as a protected class when it comes to as a part of race and ethnicity. All right, so looking ahead. So on the heels of the New York City restrictions on artificial intelligence, the Equal Employment Opportunity Commission is reviewing discrimination concerns. They have an upcoming public hearing on this. They're really concerned that unvetted artificial intelligence tools when it comes to screening candidates, making employment decisions, things like that, have a high risk of being biased or discriminatory. So the EEOC is all over that. They're looking to make sure that there is some vetting going on to make sure that use of artificial intelligence, which is growing at an exponential rate, does not create intentional or unintentional bias concerns. Also, a lot of focus on age discrimination. We're seeing a lot of litigation and lawsuits around this. So just as a reminder, the Older Workers Protection Act protects workers who are 40 years of age or older from age discrimination. In terms of what we're seeing on the cases, it's a lot of times an employee being fired or sometimes just demoted from a management or a senior level position and in place of a younger worker. So definitely a lot around age discrimination going on right now. We expect for the trend of pay transparency laws at the state level to continue and spread to additional states. And then we're also seeing a lot of litigation around exempt and non-exempt. So, these are usually on a job title or industry by industry basis. Everything from cable installers to the people handing out samples at warehouse clubs, who, by the way, were found to be exempt outside salespeople. So, go figure. All right. So it looks like we excuse me, answered the question that we did have. Certainly, if any questions didn't come to mind during the presentation, but come up afterwards, do feel free to reach out to us at any time. We're happy to have a dialogue and help you with your compliance, both at federal, state, and city level. But with that, I will hand things back over to Katie.
Thank you, Paul. To learn more about MP's full solution services for 2023 and more, I just will drop a link into the chat that will connect you with an MP team member. Be sure to join us next week on the same day and time for our upcoming webinar, Employee Retention Tax Credit, ERTC, the latest guidance. Visit our website to register and to see the full calendar of upcoming events and available resources. Thanks for joining us today and have a great rest of your day. Thanks. Bye.